The moment separation becomes real, one of the first things both spouses want to know is, do I have to leave? Do they have to leave? Who actually gets to stay in this house while all of this is being sorted out? It's not as simple as whoever bought it, whoever pays the mortgage, or whoever wants it more. Florida law has specific rules about this, and the answers have direct impact on your home's eventual sale. Let's talk through how this works. I'm Amanda Sweets, Realtor with Keller Williams Realty of the Palm Beaches. I work with divorcing homeowners throughout Palm Beach County. This is part of a full series on divorce real estate. Let's get into today's topic. And, as always, I'm a real estate professional, not an attorney. Everything I share today is for informational purposes. Your divorce attorney is your best resource for the legal specifics of your situation. In Florida, during divorce proceedings, either spouse can petition the court for what's called exclusive use and occupancy of the marital home. That's the legal term for the right to stay in the house while the divorce is being resolved. Courts consider several factors when making this determination. Children. This is the biggest factor. If minor children are involved and one parent is the primary caregiver, courts frequently award temporary occupancy to that parent, with the reasoning that keeping children in the family home maintains stability during an already disruptive time. We'll come back to kids in a dedicated video later. Financial contribution. Courts may also consider who is better positioned financially to maintain the home, covering the mortgage, taxes, insurance, and upkeep during the pendency of the divorce. Safety concerns. Is there documented domestic violence or safety concerns? Courts can issue orders removing one spouse from the home immediately. This is a different and more urgent legal process, and if this applies to your situation, please speak with your attorney right away. Occupancy during divorce is temporary. It does not determine who owns the home or who receives equity at closing. Here's where things get financially complicated and where I see a lot of disagreement arise. While one spouse is living in the home during proceedings, the mortgage is still being paid, taxes and insurance are still accruing, the HOA still sends a bill, the lawn still needs to be cut. Who pays for all of that? The answer depends on what the court orders or what the parties agree to. In many cases, the occupying spouse is responsible for ongoing carrying costs during their occupancy because they're receiving the benefit of living in the home. But this is negotiable and varies case by case. Why this matters for the eventual sale. If the mortgage goes unpaid, even temporarily, even while both parties are arguing about who's responsible, it damages both spouses' credits and it can cloud the title, creating problems at closing. I've seen sales delayed or fall apart because of mortgage delinquencies that happened during the separation. Keep the mortgage current during separation. Missed payments affect both parties' credit and can complicate the eventual sale. Here's something people don't always connect. Who's living in the home during the listing period has a real impact on how the home shows and how quickly it sells. When the occupying spouse is cooperative, motivated to sell, and keeps the home in showing condition, things go smoothly. When the occupying spouse is resistant to the sale, things can get very difficult very quickly. I've had situations where the occupying spouse refused to allow showings at reasonable hours, left the home in poor condition for showings, refused to vacate for open houses. These things directly harm both parties' financial outcome. When I work with divorcing clients, one of the first conversations we have is about showing logistics, establishing clear expectations about access, notice periods, and presentation standards. Getting this in writing as part of the listing agreement or even as part of the divorce agreement prevents a lot of conflict. The goal is always the same: get the best possible price for both parties, and that requires the home to be accessible and presentable. One thing I encourage divorcing homeowners to do, even before they've made final decisions about the home, is to bring in a real estate professional early. Not to list the home immediately, but to get a realistic picture of what the home is worth. What will it net after payoff, and what the timeline looks like for the sale. This information is valuable for the attorneys. It helps both parties negotiate from a foundation of real numbers rather than emotional assumptions. I've done consultations where both spouses walked in expecting very different things from the sale, and the CMA I provided was the first time they actually aligned on what the home was worth. That's a powerful thing, and it costs nothing. I offer free consultations for divorcing homeowners at any stage of the process. The question of who stays in the house is one courts deal with regularly, and it's temporary. What matters most is that you and your attorney understand the financial implications of who's in the home and on what terms during the listing period. In the next video, I'm going to talk about something that affects the actual dollars you walk away with: how to price and prepare your home for sale when you and your spouse may not agree on everything. That's a real challenge, and I've got practical strategies for it. Download the free checklist in the description, subscribe for the rest of the series, and reach out if you'd like to talk through your situation. I'm Amanda Sweets, and I'll see you in the next video. Until then, take care of yourself, and remember, your next chapter is your best.